Excellence webinar series, which is sponsored by Black Hills IP and the SLW Institute. Black Hills IP is a U.S.-based service provider offering IP docketing, paralegal, and analytics and annuities services. The SLW Institute is an educational group created by the Schwegman Lundberg Wissner firm, which aims to provide insightful and useful information to the IP community. For this webinar series, we have pulled together experts to talk about strategies and best practices for patenting in key foreign countries. The Foreign Excellence webinar series is free. This is the third one of several monthly webinars in this series. The schedule and registration information for upcoming webinars is listed on our website. To register for any of the future webinars, go to the tab for Educational Resources on the Black Hills IP website, which is www.blackhillsip.com. The webinar that we are presenting today will focus on Korea. We've allowed time for questions at the end of the webinar. Questions may be submitted using the question button on the right-hand side of your browser window. You can submit a question at any time during the presentation. The question will be held in a queue until the end of the presentation. The presenters today are myself, Russ Slifer, D.H. Yang, and Peter Paik. I'm Ann McCracken, the president of Black Hills IP. I'm a patent attorney with 20 years experience in patent prosecution. I was a partner at the Schwegman firm for 10 years, and I also was a full-time law professor and directed the patent prosecution program at Franklin Pierce Law Center for 5 years. Russ, please introduce yourself to the audience.
Thank you, Ann. I'm Russ Slifer. I'm a principal at Schwegman Lundberg Wissner. Prior to that, I was the Deputy Director of the United States Patent and Trademark Office. And prior to that, I was the Chief Patent Counsel at Micron Technology.
Thank you, Russ. D.H., please tell the audience about yourself.
Hello, I'm D.H. Yang. I have been worked for Kim and Chang as a Korean patent attorney since 2008. Before that, I worked as an engineer, electrical engineer for a Korean company for 3 years. I have been advising and representing mostly foreign clients in high-tech industries for prosecution and litigation matters. Thank you.
Great, thank you, D.H. Peter, please tell the audience about yourself.
Hello, I'm Peter Paik, a senior patent foreign attorney at Kim and Chang. I'm a member of our IP group's electrical and chemical practice group. I have about 12 years of patent litigation and prosecution experience. Before going to law school, I worked as an engineer at ExxonMobil. Thank you.
Well, thank you all for your time today. We really appreciate it. Today, we're discussing various aspects of patenting in Korea. First, Russ is going to present some data and look at filing trends in Korea. And then Peter and D.H. will talk about the patent process in Korea. So at this point, I'm going to turn it over to Russ.
Thank you, Ann. I thought I'd start off the presentation and talk a little bit about international patent strategies, which aren't easy and frankly should be different for every patent as we're looking for your client and yourself at different countries to file in. And issues to consider when looking at countries, the size of the domestic market that you're going to be selling into, the competitors' R&D and manufacturing locations, and even your manufacturing locations. So you want to consider the state of the domestic IP system. Is it strong? What's the operation of the patent office look like? Is it fast? Is it collaborative with other offices around the world? Do they have strong searching capabilities? What are the enforcement mechanisms in the country? Are they favorable to patent owners or favorable to infringers or fairly neutral? Is an international patent strategy, as you develop an international patent strategy, obviously you need to look at the cost. It's expensive. So the cost, both country by country and cumulative, should be considered. And finally, it's important to think 5 to 10 years into the future. which is complicated with changes in both national policy for IP, combine that with changes in enforcement and judicial decisions. But looking to the future is most important. So looking at this slide, we can see that Korea is ranked, it's not shown on the slide, but they're ranked about 27th in the world in population with 51 million people. The GDP is 12th in the world and looks very similar to China with close to 40% of its GDP in the industrial sectors. So obviously Korea is a country to look at seriously when considering your international strategy. Next slide, please. So turning to the top technologies that are filed in KIPO, the cumulative amount of these of the filings shown on this slide is about 60% of the applications filed in Korea. And the top 4 technology areas, I believe, clearly show that the high-tech sectors, semiconductors, electrical industries, and computer technology view Korea as a strategic location for patent protection. The technology areas also, I believe, are an indication of KIPO's examination strength and the depth of Korean prior art. Next slide. This slide shows a comparison of Korean domestic companies and international companies as patent holders. I believe this slide can help reveal some business views of the Korean IP system. Here, the top 7 Korean companies filing in Korea are LG and its subsidiaries, Samsung, Hyundai, and Daewoo. And I don't think there's anything unusual there. These are some of the top Korean companies. Interesting to me, however, is that POSCO is a steel manufacturer and they have 1,400 issued patents. Turning to the international filers, the top international patent owners are all high-tech companies from the US and Japan. And Qualcomm leads the international patent owners. This, to me, indicates that Qualcomm has viewed and continues to view Korea as a favorable country to enforce patents while they seek to license those patents. Next slide. Since the Foreign Excellence series has already covered China and Japan, this slide shows the filing trends in all 3 countries. Both Japan and Korea have been holding steady over the last 5 years with low single-digit growth. And I know this ends in 2015 on the slide, but I believe the last 2 years are still following that trend. In comparison, the patent filings in China have grown at double-digit levels year over year. This shows that the perception of Japan and Korea have remained fairly constant, while the perception of China as a country to protect IP has become more favorable. Next slide. So this slide looks at patent grants to non-resident filers, and there's no surprise that China's grants would increase as the filing numbers from the previous slide show that they've been increasing at more than 10% per year. Here, both Korea and Japan have held rather steady, with Korea averaging about 64% allowance rate, while Japan is at a 78% allowance rate. And I pulled those numbers just comparing these 2 slides. It's not scientific, and I know it doesn't include all of the filing, but it gives an indication that the allowance rate in Japan is slightly higher than the allowance rate in Korea. Next slide. This slide is helpful to just frankly confirm that the number of patents in force in these 3 countries are growing, but at different rates as indicated by the previous slides. As expected, China's growth quickly passed Korea in the patents in force back in 2012, and is catching up to the patents in force in Japan fairly quickly. And in fact, when we look at the 2016 and 17 data when it's available, I think that China will probably have passed Japan by that time. Next slide. So I mentioned earlier about considering the cost, and this slide shows using Global IP Estimator the cost of obtaining a patent based on national phase filing for both China, Japan, and Korea. The takeaway probably is that the cost in each of these countries, the total cost to obtain a patent and maintain it through the life of that patent are relatively the same at $25,000 each. But the lower part of the bar represents the cost for filing, examination, prosecution, and granting costs, and that includes an estimation of attorney cost and translation cost. And you can see that the cost for China and Korea are fairly similar, with probably close to a 40% increase in cost to obtain a patent in Japan, but the annuity rates are different if you're going to keep it for the entire life of the patent. Next slide. So this is my final slide of the presentation. I wanted to take a quick look at the efficiency of examination at KIPO. While the major patent offices remain focused on improving both first office action timing and overall backlog, KIPO has been more successful than the US in reaching first office actions in less than 12 months. The USPTO right now is about 16 months for a first office action pendency, while KIPO has been below 12 months for the last several years. So both DH and Peter are going to take us through a more detailed review of prosecution and enforcement in Korea. So with that, I'll turn it back to you, Anne.
Thank you. Peter and DH, I'm going to hand it over to you to talk about the prosecution process in Korea.
Thank you, Anne. We will go through 3 different topics on Korean patent system. First, I will share with you some of the latest IP trends and developments in Korea, efforts made by Korean Patent Office called KIPO, and also on the court side, and which will be followed by a presentation by my colleague D.H. Yang, focusing on patent prosecution process. And finally, I'll cover the enforcement landscape in Korea. Next slide. Okay, next slide, please. So this slide shows the trends of the volumes of patent filings since the data has been tracked since about 2000. As you can see, the volume of patent filings has steadily increased over time, whereas for design and utility model has decreased. And looking at the design filings, it has stayed somewhat steady, but there was a noticeable increase when there was a renewed interest for filing designs around the time when there was a Apple-Samsung litigation. This was in around 2012. When you look at closely at the data, I think going back to the point raised by Russ earlier, the most increase in the volumes, patent filings are in industries that Korea is known to be strong in. Semiconductors, electronics, digital and telecommunications, by companies like Samsung and LG. As you may know, Samsung ranks very high in terms of the number of filings in the US, and they actually do a much higher volumes of original filings in Korea. So I think they rank very high as one of the most active patent filers in Korea. Next slide. Next slide. Okay. Just wanted to go through some of the efforts involving the KAIPO, what KAIPO has been trying to do. As discussed by Russ, about the pendency period, which is measured from the time the examination request is made until a first office action is issued. KAIPO has been trying to make efforts to keep it relatively within 1 year. Before, it used to be longer, longer than about 13 months, sometimes 14 to 15 months, but has been making a lot of investments, recruiting a lot of examiners to keep the pendency period just below 1 year. And KAIPO also has been making efforts to reduce the overall invalidation rates, which is now down to about 45% in 2015. Before it was as high as 70%, and there were concerns about the quality of examinations given the high invalidity rate, and they have made great efforts to improve the quality of the examinations. And KAIPO also has introduced various ways to expedite examination, so that will taking advantage of those expedited examination options will result in first office action being issued sometimes as early as within 2 months. So there are options available to the applicant to build your patent portfolio in Korea quite rapidly. So as a result of efforts made by KAIPO to improve and reduce the invalidation rates, the potential effect of that is that examiners could be more rigorous in examinations, which also translates into possibly lower allowance rate. And applicant may need to file appeals after you get final rejections. And in view of sort of the possible effects, possible responses the applicant can consider is to increase interaction with examiners for high-value cases, such as conducting examiner interviews either in person or over the phone. And also, it's critical to keep in mind that KAIPO examiners tend to pay closer attention to examination results in other jurisdictions. So applicants need to keep in mind how they may affect Korean prosecution. Also, because of limited opportunities to file divisionals, continuation application in Korea, it may be helpful for high-value cases that may consider keeping a placeholder divisional to ensure opportunities to continue prosecution. Next slide. So on the court side, the patent court, which is sort of Korean equivalent of Federal Circuit in the US, has been making efforts to make Korea a more attractive jurisdiction to resolve patent disputes, not just for Korean companies, for non-resident companies as well, and make it more pro-patentee, which is in line with KAIPO's efforts to improve the quality of examinations. So make it more pro-patentee, even for non-resident patentees. So as a part of such efforts, there are plans to set up international court panel to hold oral hearings in English, and also plan to provide court decisions in both English and Korean. There was actually a pilot preparation step in June of this year. There was a first oral hearing conducted in English. Also, there are plans to amend and introduce new legislation to increase damages award. Also, given limited discovery available in Korea, they're trying to reduce the burden of patentee, improving the damages amount resulting from infringement. And as a result of such efforts made by Korean courts, we anticipate that the amount of damages award may increase, and also they're trying to make litigation in Korea may increase in terms of volume, not just initiated by Korean companies, but there may be more disputes between non-resident companies, and also attracting non-practicing entities to litigate their patents in Korea. With that, let me turn it over to DH, and he's going to present on patent prosecution in Korea.
Thank you, Peter. Next slide, please. I will start from procedure and timeline. Let's go through this overview chart from top to the bottom. Like the US, Japan, and China, which give only 30 months from earliest priority date for PCT national entry, you will have 31 months in Korea. For PCT applications now entering into Korea, you may get one more month to file English translation. So, meaning that you can file the Korean translation of PCT spec by 32 months. However, even when you utilize this extra 1 month, you should keep in mind that you still need to submit a petition by the 31-month deadline. If you file nothing by the 31-month deadline, it is almost impossible to revive the prosecution opportunity in Korea. So don't forget to send the filing instruction to your local agent in Korea before the 31-month deadline. Similarly, for direct filing under the Paris Convention, you may first file an English spec and then submit the Korean translation within 1 month. This not only allows 1 extra month to prepare translation, but also has another benefit that you can later amend the Korean translation based on the English spec. Korea has deferred examination system in which you need to file a request for examination to get your application examined. Many clients use this examination request to delay prosecution in Korea for various reasons. For example, you may want to wait until you find a target product in Korea and then draft your Korean claims to better read on the target product. On the contrary, if you want to accelerate examination and at some point in Korea, there are various ways to do so. For example, if you have an authorized search agency provide prior search result to KIPO at your cost, KIPO will put your application on the expedited route, requiring nothing more. And as Ross mentioned before, KIPO's examination run fast compared to other jurisdictions. On average, in about 1 year from examination request, you can receive the examination result. If your application is examined under the expedited route, you will get the examination result within about 4 months from examination result request. If you receive a preliminary rejection, you will have maximum 6 months to respond. Unlike the US, you need to file a petition for time extension before the current deadline lapses. If you fail to overcome the preliminary rejection, a final rejection will be issued. Next slide. If you want to pursue the pending claim set as is in response to final rejection, you need to file an appeal before IPTAB, which is equivalent to PTAB in US. Or you can amend claims, then the examiner will reconsider your application. In response to the final rejection, only narrowing or clarifying amendments are allowed, while there is no such limitation when responding to the preliminary rejection. If you want to amend the claim more freely, you can file a divisional. If the examiner thinks rejection grounds still remain even with the amendments, he or she issues a second final rejection. In response to the second final rejection, you can only file an appeal without any amendment. You can also file a divisional after the second final rejection is issued. Lastly, as indicated in the slide, you will have maximum 90 days to respond to the final rejection, either first or second. Next slide. Now I'm talking about software invention in Korea. With respect to subject matter eligibility, Korea is more lenient than US. The abstract idea itself is not patentable subject matter in Korea like in the US, but basically if you add some hardware type component and draft claims in certain allowed formats, then you can easily pass eligibility tests in Korea. Until now, Korea did not introduce any ELIS or Mayo's significantly more type of tests for subject matter eligibility, to my knowledge. Still, this is a kind of a untouched ground in Korea, so we need to keep closely monitoring further development. Next slide. These are the claim formats allowed for software invention in Korea. Apparatus, process, computer readable medium, and computer program stored on a medium. While program itself, program product, or something like that are not allowed in Korea, the first allowed category, computer program stored on a medium, was introduced a few years ago. When introducing this new format, Kaipo explained that it would have substantially the same scope as the third one, the medium claim. However, it is remained to be seen how the court will interpret the scope of this first format. Next slide. Now I will give you some quick practical tips for patent prosecution in Korea. For Korea, you may want to consider having more independent claims. Although the validity is reviewed claim by claim basis, and principally and logically, there should be no differences between independent and dependent claims. But our experience tells that there are something psychological to make independent claim to better survive. And unlike many other jurisdictions, there's no limitation on the number of independent claims in one application in Korea. And the official fee is the same, either independent or dependent. So having more independent claims with varying scope can be a good choice without further incurring cost in Korea. Next slide. Korean examiners are not bound to, but very keen to what happened in foreign family applications. They are very actively using so-called IP dossier, as you know, which show Korea, US, Europe, and Japan and China's file histories at once. Particularly since EP and Japan's inventiveness standard is more similar to that of Korea than US. So Korean examiners tend to put more emphasis on EP or JP allowance. However, I don't think that replacing the Korean claims entirely with foreign allowed claims would be a good choice, because if the foreign counterpart is challenged and found to be valid at a later stage, such result may have a more direct negative impact on the same Korean claims. So you may want to keep some different Korean claims and add some allowed claims from other countries, and again, as additional independent claims. Next slide. And unlike the US, there is no duty to disclosure in Korea, and so no rebuttable presumption of validity in Korea. So a broader patent in Korea is relatively vulnerable if foreign counterpart claims are narrowed or even abandoned due to some prior art. So if you got to know a prior art which is not cited by Korean examiners, you may consider adding a narrow independent claim to address such prior art as a fallback position. Next slide. And this is my last slide. And lastly, differently from US practice, as far as I know, for inventiveness tests in Korea, advantageous effect are treated as one of the important factors. In other words, mere structural differences may not warrant inventiveness or even novelty in Korea. So if advantageous effects are written in the specification, you can make a stronger argument than when there is no description in the specification. So for applications that specifically target Korea, you may consider putting as many advantageous effects as possible in the specification. I'll now turn to Peter for the rest of the slides.
Thank you, DH. So now I will cover as a last topic the enforced patent IP litigation landscape in Korea. First, on different options available to enforce your IP rights, and also sort of how the court system is set up, and also the procedure, the timeline, and how proceedings are progress. And lastly, of the several options that may be somewhat unique to Korea, I will cover them in more detail. Next slide. So again, there are a number of different IP enforcement options available in Korea. Of course, civil actions, most often that are filed. There are different types of either main action and preliminary injunction action. One thing to keep in mind in the main action, a permanent injunction is automatically granted if there's a finding of infringement. That's one thing to note. The second, in the KAIPO administrative action, it's filed for either patent, utility model, design, and trademark. It's the tribunal within. Oh, could you go back one slide? Yes. So KAIPO administrative actions, there are different types: invalidation/nullity action, cancellation action, scope confirmation action, and correction action. Just to briefly go through invalidation action, cancellation action, as you can tell, it relates to the validity of the patents. Scope confirmation action is one where it's an advisory decision in a way which is not enforceable. You bring an action either as a patentee or a party that may be accused of infringement. You're asking the patent office to render a decision whether a particular product or method may or may not fall within the scope of a patent. Correction action is one that you file with the patent office to make a post-grant amendment. Again, all these administrative actions are filed with a tribunal within KAIPO called the Intellectual Property Tribunal and an appeal board. What's interesting about IP enforcement option in Korea is you can actually bring, it's in the Patent Act, you can bring a criminal action. I mean, this you resort to criminal action, but traditionally mainly for trade secret and trademark infringement. They're rare for patent enforcement, but at times, if there's a clear evidence of intent on the part of the accused infringer that they're infringing on the patent with the intent to infringe, then there are ways you can use a criminal action to leverage. As you can imagine, that law enforcement authorities will get involved, and I mean, of course they will give a lot of deference to on the courtside proceedings because they don't have the expertise nor experience to review claim construction or validity issues. But at the same time, this can actually be a good tactic that to really to enforce your IP. And also you can file create a trade commission action. Trade commission is equivalent to the USITC. For they have the jurisdiction and empowered to police unfair trade practices, and you can assert your patent with the Korea Trade Commission, and also with the Korea Customs actions with the Korean Customs. Traditionally, again, that they're mainly for trademark, but now you can enforce patent, and there are various other measures that, of course, sending a cease and desist letters and other discussions. And I will cover the Korea Trade Commission action and Korean Customs action in more detail in the later slides. Next slide, please. Okay, so this gives you a sort of quick overview of how the Korean court system is set up when it comes to patent enforcement. It's bifurcated. The current system actually was set up starting 2016. Before they were sort of bifurcated up to the intermediate appellate court, with the patent court reviewing only validity issues, and the high court reviewing the patent infringement action. But now, as of January 1st, 2016, those reviews have been converged and conducted by the patent court. So all validity issues, a tribunal within KIPO, again called IPTAB, has exclusive jurisdiction to declare a patent invalid. And this is a tribunal within which you bring an invalidation action and other types of KIPO administrative action. Any decisions rendered by IPTAB will be appealed to the patent court. Now, turning to the right side of this is, of course, you file an infringement action with the district court, either civil action or criminal actions in the form of main action. And again, any appeals from district court will be reviewed by the patent court. One thing to keep in mind is the appellate level review in Korea is on a de novo basis. So you're allowed to make new arguments and also introduce new evidence. But any further appeal from the patent court to the Supreme Court, the scope of review is limited to the issues, the questions of law. Next slide. So this chart just shows you a sort of overall timeline of how typical timeline of how Korean patent litigation proceeds. From the time of filing a complaint, it typically takes 10 to 18 months until a decision is rendered by the first instance decision rendered by a district court. Unlike in the U.S., Korea has a very limited discovery, and you have a lot of flexibility to introduce new evidence and arguments. Usually start out with several rounds of brief exchanges with a complaint filed, an answer, and a reply brief, etc. And once with the following the initial exchange of briefs, there will be a series of hearings, usually from 4 to 5, and depending on whether any damages claim is made, there may be several more hearings. So again, it takes about 10 to 18 months for the first instance decision to be rendered. And following that, any appeals from the district court, the intermediate appellate court is the patent court, and they typically hold about 2 to 3 hearings, and it takes about 8 to 14 months for the decision to be rendered. And any further appeal from the patent court up to Supreme Court, the timeline can vary very significantly depending on whether, of course, the Supreme Court will be selective in reviewing appeals from the patent court. In the event they decide to summarily deny cert, and in which case they will issue summary dismissal, the time frame will be only about 3 to 5 months. Whereas if they decide to conduct substantive review of the appeal from the patent court, in which case it could take 1 to 2 years for the final decisions to be rendered by the Supreme Court. On the lower track is where how the invalidation action will proceed, and it's fairly typical, almost as a knee-jerk reaction by the accused infringer, a defendant, to bring an invalidation action subsequent to filing of a complaint. And again, IPTAB will review the invalidation action, and depending on whether there's any related infringement actions, or depending on, you can also file a request to have the invalidation action reviewed on an expedited basis, or there are other bases to expedite the proceedings. It can be significantly, the time frame can be significantly shortened, and sometimes you can get a decision as soon as 4 months, or it could take as late as 14 months on average. And subsequent appeal from the patent court to the patent court, the period overall could range from 7 to 12 months. And finally, the appeal to the Supreme Court, it's the same as, again, depending on whether summary dismissal is issued or substantive review is undertaken, it could vary from 3 to 5 months, or as long as 1 to 2 years. Next slide. So one interesting enforcement option in Korea available is you can bring a KTC action, and there's actually a statutory basis where the Korea Trade Commission is empowered to investigate and then police unfair trade practices and grant remedies against injury of domestic industry. That being said, KTC is empowered to initiate investigation, again, to impose sanctions for unfair trade practices, analogous to USITC. And oftentimes, what's interesting, as a statutory basis, that you grant remedies against injury of domestic industry, but if there's a finding of infringement, the scope of unfair trade practices relate to import and export. Whereas the USITC, they will only review imports, but for KTC, they can also prevent and prohibit export of products that are found to have infringed the IP rights at issue. So import, export, manufacture for the purpose of export, supply to Korea of the products infringing intellectual property rights. So if you're able to really fairly have a very clear evidence, usually KTC action will be brought once you file a patent infringement, you get a decision. As you imagine, they may lack expertise to review patent issues, as well as the court may be able to. And this can be a great option to bring, if in the event you have a court decision in your favor as a patentee. But at the same time, you know, the commission, they're more of an expertise on trade-related issues, so they have limited experience in handling complex patent cases. So again, they will give a great deal of deference to decisions rendered by in the courts or KIPO with more expertise and experience in handling patent cases. So this is one option you can consider, where you have a favorable decisions from other tribunal and further enforce that. Because as you can imagine, if you have a decision for KTC saying that there's an infringement, for example, against companies like Samsung on certain patent, that could be a very powerful option to enforce your IP rights. Next slide. This is my last slide that I'm going to briefly cover on the Korea Customs action. Again, this traditionally being used for trademark enforcement, where Korean customs agents will review products, counterfeit products, that is fairly straightforward to see whether there is issue of trademark infringement. But pursuant to Korea US FTA, patent and design rights have been added as IPR that can be protected through customs actions. And there are a series of steps to have your patent registered with the Korean customs so that they can monitor products. And once the accused potentially infringing products are detained, and then you have to sort of show evidence to have those infringing products continuously detained. You have to actually file an infringement action to maintain suspension of the products being released. And there's a series of steps that will follow, whether the exporter or importer can file a petition seeking release of the goods. But this also, again, can be a very effective option when it comes to product that you can easily monitor as being imported or exported in and out of Korea. At the same time, because of this has just been recently introduced, it's not yet widely used for patent enforcement to our knowledge. With that, let me just conclude our presentation.
First, I want to thank Russ, Peter, and DH for that great presentation and these really great materials that you've prepared. Your overview on the trends and the patent process and the enforcement information was great. Thank you so much. I want to also remind the audience that you can submit questions with the question button on the right-hand side of your screen. And while we're waiting for questions, if anyone is interested in learning more about Black Hills IP Services, please contact our Vice President of Sales, Jim Brophy. His contact information is on the screen. If you'd like more information about the SLW Institute, please contact Brian Ness at the contact information on the screen. And if you are interested in services from Kim and Chang, Peter or DH, I'm sure, would be happy to talk to you, and their contact information was earlier on these slides, which will be made available on our website in a couple days after this program. I do have a couple of questions. Here's the first question. If the first claim is not allowed, could other claims be found allowable, or are all the claims rejected? Peter or DH, can you respond to that?
You're saying if the first claim is rejected and its dependent claims, your question is whether its dependent claims will also be rejected or not?
I would read it that way, yes.
Okay. It depends. I think the examiner will look at it, sort of the narrowing limitation that was added in the dependent claims, and whether the features or narrowing features are in the dependent claims will render the invention, the claim subject matter inventive, that will not lead to automatic rejection. But again, I think we need to keep in mind sort of one of the critical indication in establishing inventive step on the Korean patent practice is so-called the working effect. And when you argue and see that with the independent claim, probably the broadest claim rejected, you will need to sort of establish what additional working effects will be brought as a result of this limiting narrowing feature in the dependent claims. And you were successful in persuading the examiner, you'll get allowance for those narrowed claims. DH, do you have any further comments?
Yes. If you mean that if one of the claim set was rejected and then whether the application as a whole can be allowed or not, there is an all or nothing rule applies to Korean applications. So application will be treated as a whole. So if there is a rejection ground for even only one claim, your application will be rejected as a whole. But when you come to the invalidation action, the claims will be reviewed by claim basis.
So, DH, in prosecution then, if one of the claims is rejected, can you cancel it in a similar fashion to how we cancel a rejected claim in the U.S. so that the remaining claims are allowable and the application can be allowed?
Yes.
Okay. Good. I have another question also related to claims. This one deals with the fees. You had explained that the claim fees, when you file the application, are the same for an independent claim or a dependent claim, and suggested more, including more independent claims, which I think is a great practice tip. Is there a base number of claims that you get? Is like in the U.S. we have a base filing fee, and you get a total of 20 claims for that, and then additional claim fees apply beyond that. Is there a base number of claims that you get for your fee in Korea?
I'll say no, because for the first claim, you should pay some higher fee, but after that, the fees are same for as for any claims.
So again, you need to file a separate request for examination for having your claims examined by the examined. And there's a basic fee for the first claim, and there's an incremental amount for each additional claim, which is not as significant as the basic fee. But again, it's charged at the same rate. Right.
Okay. Then one further question. This again relates to prosecution. You noted that it's a good practice to put advantages in the specification, and even suggested putting as many advantages in as you can. In the U.S., we typically avoid calling out advantages, or at least labeling them as advantages. So if we have a application that we're filing in Korea that's claiming priority to a U.S. application, we would not have had the advantages in the U.S. application. What do you recommend we do? Can we put them in the Korean application even though they're not specified in the priority application? Or how do you reconcile those two practices?
If there is no description on advantages effect on the first filing, I would not recommend adding that in Korean specification, because that would make some problem on the scope of priority claim. And yeah, but we can argue advantageous effects that are not described in the specification. The reason why I emphasize on including advantageous effect in specification is by which we can make a stronger argument, but we can still make argument on advantageous effects. So you can discuss with your local agent like us to make argument on advantageous effect for Korean prosecution at a later stage.
Okay.
Needed.
Okay, good. Thank you. That's all we have for questions, and we're also just about out of time, so I think we timed this perfectly. Before we end, I'd like to introduce our next webinar in the Foreign Excellence webinar series. The next webinar will focus on the patent process in Canada. It will be presented on Thursday, January 18th at 1 p.m. Central Time. So again, I want to thank our presenters today and thank our audience for signing in today. We hope you'll join us for the next webinar in Canada and other future webinars in the Foreign Excellence webinar series. Thank you very much.